Please like, share, and subscribe. Don't hesitate to comment so that we can catch up well.
In this lesson on criminal law, what I want to do is talk about the concept of the burden of proof. Specifically, what we're going to do is really introduce some of the basic principles of criminal law. And we're going to begin by looking at the concept of the burden of proof and the types of burdens of proof that exist within our legal system. We're also in the next lesson going to start to introduce some other concepts of criminal law, concepts such as actus reus and mens rea, which are the sort of elements of criminal liability. But we're going to introduce the concept of burden of proof. We're going to look at the human rights implications when it comes to a number of examples of burden of proof, specifically being on the onus of the defendant. And then we're going to look at the distinction between evidential burdens versus legal burdens, what the two are, how they are shown, and what the standards of proof are for each different type of burden. So, we should really note that criminal law, as it stands today, doesn't have the same kind of statutory framework as other areas of law. There isn't this kind of interconnectivity of all the different legal provisions within criminal law. As such, there are a number of conceptual principles that we use to link and to thread the different ideas of criminal law together. And these include things like criminal liability, the modes of criminal liability, specifically actus reus and mens rea, that we'll look at in the next lesson. But there are also some other principles that exist, one of them being burdens of proof. Now, it's important to note that this lesson is just going to cover an introduction to the concept of burden of proof. We're only going to be describing burden of proof and explaining it to the level of detail required to understand criminal law, because there is a distinction between criminal law and the law of evidence, and burden of proof really falls under the remit of the law of evidence in a much major way. So we're only going to be doing burden of proof to the extent that it's relevant in criminal law. So in a jury trial, the concept of law are generally matters for a judge, and the concept of facts, the matters of facts, are for the jury. They're a matter for the jury. This is the distinction between law and fact when it comes to a jury trial. And this is what happens in criminal proceedings. You will have a judge who will direct a jury as to the specific legal implications of a particular case, and it's up to the jury to decide on the facts of the case, to decide the different kinds of responses to particular facts of a case. Now, this is a distinction that is observed at Crown Court level and also at Magistrates Court level as well. It's a very common distinction when there is often contention. And as we will see when we start to build up our knowledge of more and more cases and more different cases pertaining to particular crimes, we will see this becoming more and more relevant. And that's not to say that in every single case an appeal will not rest on the matters of fact, but just in the most circumstances it's normally a matter of law rather than a matter of fact. So the essential principle of criminal trials is that prosecution has to prove the facts that entail criminal liability. Okay. This should be noted, it's not always the case, but we will see in later lessons when we're talking, for example, about insanity. But it's often the case that it is under the remit of the prosecution to prove the facts of the case and to prove criminal liability, to prove that the defendant is guilty of a particular crime. And this is a principle that came really solidified in the common law in Wilmington and DPP, Director of Public Prosecutions. I should also note that I'm using just the shorthand title for these cases. The actual full reference for the cases will be in the description. But in this case, it was said by Lord Sankey LC that it is the duty of the prosecution to prove the prisoner at the time they were called prisoners, to prove the prisoner's guilt, subject to the defence of insanity and subject to any statutory exemption. So really, it was in this case that the concept of the burden of proof and the fact that the burden of proof, the onus of the burden of proof was on the prosecution rather than the defendant, this was solidified. And it was actually in this case where we... Wilmington specifically, the facts of the case were that Wilmington had shot his wife, he had claimed that this was an accident, and the trial judge directed the jury and directed that it was actually up to the defendant to prove this to be the case, to prove that this was an accident. And on appeal, this was something that was overturned, as we can see here in these quotes. We've got another quote here, again from Lord Sankey, that while the prosecution must prove the guilt of the prisoner, there is no such burden laid on the prisoner to prove his innocence, and it is sufficient for him to raise a doubt to his guilt. So this is really just confirming and solidifying the concept of burden of proof and the fact that the onus is on the prosecution. It was held that it is up to the prosecution to prove that he had not only killed his wife, something that he had admitted to, but that he had also had the necessary state of mind for this criminal liability. And more on this when we talk about mens rea in the next lesson. Lord Sankey does go on to highlight a number of exemptions to this principle, to the burden of proof, because really, the main exemptions of this are the common law exemption in the defence of insanity, as is noted in the first quote. If we go back here, if we notice here in this quote here, the defence of insanity subject to any statutory exemption. So this actually highlights the two exemptions that Lord Sankey highlights, one being the defence of insanity and the second one being statutory exemptions, because don't forget, statute law exemptions would be valid since Parliament is sovereign. It can therefore legislate any such exemptions as it so wishes. And now this does bring into question the extent to which human rights plays when it comes to burden of proof and the law of evidence, because in this case it is shown and it is held that one notable exemption to the burden of proof is really any statute law that says otherwise, because Parliament is sovereign. So arguably, under this ruling, it could be said that Parliament could provide for a burden of proof to be on the defendant in any case, and would therefore, raise human rights concerns. And this is really where we talk about the impact of human rights, because human rights has obviously had an impact since this case. Really, the impact of human rights and the growth of human rights law in the...
Please like, share, comment, and subscribe so we can be together, get notifications
prove
together.
The guilt of a particular defendant. And there does exist a kind of lesser burden that can be placed on the defendant, and also not be in violation of human rights law. And this is known as an evidential burden. And this is really where the defendant may have an obligation to present and provide some kind of evidence pointing to a particular question of fact. So there could be some kind of evidence that they really have an obligation to present to point to a particular issue. So if, for example, we were to go back to the Wilmington case and we were to sort of rearrange the facts a little bit and come up with an alternative example, if we had said that, for example, Wilmington had claimed to have shot his wife, but that this was in self-defense, then there may be an evidential burden on the defendant to provide evidence that this was the case, to provide evidence that this was in self-defense. And this would be an example of an evidential burden if we were in an alternative reality. So, unlike the legal burden that exists and is generally in most circumstances on the onus of the prosecution, an evidential burden is generally accepted by judges as legitimate in a trial if the evidential burden, the onus of the evidential burden, is on the defendant. This is something that is generally accepted as legitimate. And there is a quote here in Lambert from Lord Stein that says that comparative experience in constitutional democracies underline the vice inherent in the transfer of legal burden provisions and the utility, in appropriate context, of evidential presumptions. Now, this is just a fancy way of saying that Lord Stein here is making clear that where the defence has a legal burden of proof, this can place a vice upon them, and it will, undermine a number of principles of the rule of law. However, it makes clear also that in certain circumstances there is an amount of utility that can be had if there is a transferal of the evidential burden to the defence. And so therefore it's making a distinction between legal and evidential burdens. And it is also saying that in most circumstances, a legal burden of proof, placed on the defendant is a bad thing, but an evidential burden of proof can actually provide some utility. So let's talk about standards of proof. Now, standards of proof relate a little bit to the concept of burden of proof, and this is the amount, the effective, the quality of proof that is required for legal prosecution. So, generally speaking, a high standard of proof is required when there is a legal burden on the prosecution. They have to prove to a high standard criminal liability. And the famous quote that I'm sure everybody knows from Wilmington and DPP is the phrase, "beyond reasonable doubt." So the prosecution has to prove beyond reasonable doubt that the defendant is guilty of the crime so charged. Today, though, they don't really use the phrase "beyond reasonable doubt." Normally, the standard of proof is simply that the juries are told that they must be sure of any guilt, which doesn't really sound as pithy, but we carry on. And really, this is the standard of proof when the legal burden of proof is it rests with the prosecution. So when the onus of the legal burden of proof rests with the prosecution, then they have to be sure of any guilt. The jury must be sure of any guilt, and this concept of high beyond reasonable doubt. So there is a high standard of proof. However, when we have cases where there is a legal burden of proof on the defendant, so for example in the case of insanity, the common law insanity defence, then the standard of proof is much lower. Then in these cases there is just the rule of the civil standard of proof, and the civil standard of proof is simply that on balance of probability, is this true, effectively. Can this be shown on balance of probabilities? There doesn't have to be a high standard of proof to show it. It doesn't have to be beyond reasonable doubt. And this was something that was held in the case of Carr Bryant. Now, the final thing I want to talk about is the concept of the standard of proof for an evidential burden. So we've talked about the standard of proof for a legal burden on the prosecution. We have talked about the standard of proof for a legal burden on the defendant. Now let's talk about the standard of proof for an evidential burden. And these are circumstances where there is only required that some evidence is made available to support the issue at hand. And this was something that was solidified by Lord Denning in Bratty. And really the requirement is made even more strong by Lord Denning here, because he said that there is a requirement, the requirement is the case even if there is ample evidence to the contrary. So this goes beyond the concept of on balance of probability. Even if there is evidence to the contrary, a standard of proof can still be met for a evidential burden. And so this means that the defendant must simply just identify or point to some particular piece of evidence, rather than there being this balance of probabilities that rests on the defendant. And it's for this reason that some criminal lawyers and some legal scholars sometimes refer to it as the burden of production of evidence, rather than any kind of burden of proof. So this really concludes our discussion of burdens of proof and standards of proof and the different kinds of proofs that exist. Obviously, this is only an introduction, seeing as this is something that we go into a lot more detail when we talk about criminal evidence. But what we're going to do in the next lesson is talk about the basic legal concepts that revolve around criminal liability, and these refer specifically to the concept of actus reus and also mens rea.